Oversight and Government Reform will come to order. Without objection, the Chair is authorized to declare a recess at any time. I appreciate the flexibility and your understanding as we had votes on the floor. Almost every member has voted. There's 23 members that have not yet voted, but 21 now. I think it's important that we start this important hearing, and appreciate all of your presence and understanding here. For more than 50 years, we had in place what was called the Wire Act. The Wire Act had a prohibition on gambling. It's why you couldn't go down to your local bookie or go down to Western Union, start wiring money and betting on who knows what. That was in place until Christmas Eve, the day before Christmas Eve in 2011. And with no input from the public or notice to Congress, a single unelected lawyer in the Office of Legal Counsel, the Department of Justice, released a 13-page memo reversing 50 years of Department of Justice precedent and an understanding that Congress had that the Wire Act was in place to prohibit the use of wires to engage in gambling. The memo that was introduced declared that the Federal Wire Act applied only to sports betting and not to all forms of betting. This reverses what the Clinton administration, the Bush administration, the Carter administration, and others had interpreted. Now, certainly with the growth and the expansion and difference of the Internet is making on all of our lives, there was this interpretation that didn't come through Congress. It didn't get the proper vetting. There was not the recourse. The point that I've made in sponsoring a piece of legislation that would take us back to Restoring America's Wire Act is that if you want to see a change, if you like a different public policy, if you want to see things done differently, our framers have put forward a process, and that is you introduce a bill, you fight for it, and you try to get it passed into law, passed through the House, passed through the Senate, and signed by the President of the United States. We don't simply make up laws by one attorney at the Department of Justice down in the bowels there at the Department of Justice. We don't erase laws. We shouldn't be creating laws. That's the whole point of this piece of legislation that I had. Nevertheless, with this OLC opinion in place, it has created quite a stir, a lot of confusion, and potentially an awful lot of problems. The reversal that the OLC put forward was contrary to a plain reading of the statute. The intent of Congress in passing the law and the longstanding position of the Criminal Division at the Justice Department. And the result is now anything connected to the Internet, desktops, laptops, tablets, smartphones, no matter your age, potentially becoming a casino. I got a problem with that. I think the country has a problem with that. And it certainly needs vetting and discussion. And again, you want to make a change? Come to Congress, introduce a bill, and make a change. But don't just change the law based on an OLC opinion. In fact, I would argue that the law actually has this confusion by this OLC memo is causing a lot of problems. I don't believe that the memo has the force of law, but there are some that are placing their bets based on this interpretation. To those individuals, those corporations, to this, you're creating an awful lot of liability for yourself and potential prosecution. The other challenge that we face is that the Internet doesn't have neat walls around it. It's not like a physical facility that we can say, all right, it works just right here. For anybody to argue that the Internet can be walled off and used in just these certain boundaries, it's a joke. Come on. Nobody with a straight face is going to come before the American people and say, well, the Internet, it's just for the people of Nevada, or it's just for the people of Rhode Island. You kidding me? You give me a good 18-year-olds in about 36 hours and you can hack through just about anything. So let's not pretend that the Internet is special for just certain people. It's one of the big moral challenges that we have, but it's also one of the challenges that we have to do in making good public policy. I believe the piece of legislation that I introduced, Restoring America's Wire Act, is a states' rights bill. There are states, Utah and Hawaii in particular, that have no gaming. right or wrong, whether you like it or not, the history of the state of Utah, the history of Hawaii is such that we have elected to have no gaming. We don't have a lottery. We have no Indian gaming. We don't have any gaming of any sort. I believe that's the purview of the individual state. If Nevada wants to have it, they've made that choice. You've got a lot of Utahns that will travel to Las Vegas or to Wendover, for instance, and go gambling. That's their choice. But what I don't want is to have gaming coming to Provo, Utah, and Salt Lake City. That's our choice. That's our state's right to say, no, you're not going to be gaming in the state of Utah. That's our decision. And that is the state's right that by pushing gaming online, we're having to deal with. There is a concern that the OLC memo threatens the right of people in certain states to decide not to have gambling within their borders. And it's not just an issue for Utah and Hawaii. It is for other states as well. A bipartisan group of 16 state attorneys general wrote a letter to the leaders of the House and Senate Judiciary Committees in 2014 urging Congress to restore the decades-long interpretation of the Wire Act. They wrote in part, quote, "The impact of the opinion in which effect opens the door to the spread of Internet gaming will have a potential significant impact on state and local law enforcement," end quote. They went on later to say, quote, "Given the inherently interstate nature of Internet gambling transactions, we anticipate that it will become increasingly difficult to effectively regulate such conduct as additional jurisdictions consider legalizing Internet gambling," end quote. Federal law enforcement officials have also expressed concerns of online gaming. For example, in 2013, the FBI stated, quote, "Online casinos are vulnerable to a wide array of criminal schemes." They went on to say, "and many provide more opportunities for criminals to launder illicit proceeds with increased anonymity," end quote. I would note a Newsweek article that came out. Department of Justice settlements regarding online poker are second only to financial institutions. Fines and settlements in excess of, I believe the specific number cited in Newsweek was $1,027,511,000. I'm getting the number wrong, but it's over $1 billion. It's got a lot of digits to it. It shows what a significant problem the Department of Justice is currently having with it. Given the increased access and reliance on technology, Congress must do its job and understand the implications of this OLC opinion. Let's also understand that you're not going to be able to distinguish if it's a 7-year-old kid or somebody who's of legal age. The Internet that is used is not going to be able to distinguish the age of that person. When you go to a physical facility, you can pretty much get a guess, and some people are carded and checked for their ages. We are raising a generation of children who are extremely comfortable with technology. They think of nothing of picking up a smartphone or tablet, entering the information about their life into it. You grow up in a generation where these games, I think they're great, they're fun, where they're playing for coins and they're spending a lot of money on Candy Crush and others. They don't necessarily know the difference between real dollars and fake dollars, real coins and fake dollars, or fake coins. The speed at which online casinos operate, coupled with their accessibility, availability, and anonymity, make it clear we need to understand more about this problem. The Congress must ensure the law is clear and that some unnamed bureaucrat down in the bowel of the Department of Justice isn't making these important decisions. This is one person's opinion, but you can tell by the wide attendance at this hearing today, it is affecting a lot of people. There was no consultation with federal law enforcement officials or with state or local law enforcement officials charged with enforcing the vast majority of the criminal laws. No opportunity for public comment. Congress is not made aware of what the Department of Justice was doing. The OLC basically just decided, based on the placement, literally, of a single comma, that the law didn't mean what everybody thought it meant for more than 50 years. The consequences were not considered. Our goal at this hearing is to discuss what the Department of Counsel failed to do. We hear from federal, state, and local law enforcement officials who have expressed concerns with online gaming, including its potential to be used for money laundering, terrorist financing, fraud, and other criminal activity. In doing so, we'll respect the 10th Amendment and examine how the borderless nature of the Internet makes it difficult, if not impossible, for states to effectively regulate online gaming, protect their states and their... I've taken an excessive amount of time. Appreciate the indulgence. I will now recognize the Ranking Member, Mr. Cummings, for his statement.
Thank you very much, Mr. Chairman. I'm going to yield to Ms. Coleman in a second, but I want our witnesses to understand that much of this is new to the Congress, and we want a full understanding of what is going on here. We're hearing from both sides, and they're coming at us with everything they've got. And what we seek is fairness. We also seek information with regard to those states that are already doing it. I am not of the belief that I don't have an attitude of cannot do. I say we can do if we have the will. The question is how does that play out? And let's not kid ourselves. This is a lot about money. Come on now. And some kind of way, we've got to make sure that whatever we do is fair, is just, but again, we want to hear both sides. As a lawyer for many, many years, I know that there's always another side. So come on, let's take a look at both sides of this issue. And so it gives me great pleasure, Mr. Chairman, to yield to my colleague, Ms. Bonnie Coleman, who hails from New Jersey. And they have online gambling, and she voted for it, and she's been someone who has been extremely active and interested in this issue. And so I will yield the rest of my time to her, and keeping in mind, Mr. Chairman, and I hope that you will give her the same latitude that you would give me in that you use 10 minutes. I'm sure she has 7 more minutes left. Thank you.
Thank you to the Ranking Member, and thank you to the Chairman. I do speak to you from a position of a little bit more knowledge and experience in this issue coming from the state of New Jersey. The law enforcement implications of online gambling are an important policy consideration. However, the evidence clearly demonstrates that with proper regulation, in-state online gambling poses no more challenges to law enforcement or risk to consumers than brick-and-mortar casinos. According to the Department of Justice, in-state online non-sports gambling is not prohibited by the Wire Act or other federal gambling laws, so states may regulate online gambling within their own borders. Currently, the 3 states, New Jersey, Nevada, and Delaware, have asserted their right to allow regulated online borders and have created strong regulatory structures to provide oversight and enforcement of their state regulations. As a member of the New Jersey State Legislature, as the Ranking Member mentioned, I had the opportunity to vote for myself. I did so because I believe that legislation offered the best opportunity to mitigate the risk associated with online gambling. Since then, I've been pleased to see that our experience in New Jersey has proven that assessment to be correct. These 3 states have not seen an increase in law enforcement challenges or consumer risks related to regulated online gambling in their state. New Jersey's Director of Gaming Enforcement reported earlier this year, and I quote, "From a regulatory standpoint, our system is working. There have been no major infractions or meltdowns or any systematic regulatory failures that would make any doubt the integrity of operations. The issues that have arisen have been dealt with appropriately, just like in brick-and-mortar casinos." The Division of Gaming Enforcement also established a comprehensive, multi-factor geolocation standard that cross-references multiple location data sources and has the capability to determine if software is being used to hide a device's location. Please take a look at the video screen. This is a slide from the company that's used in New Jersey to enforce the in-state online gambling requirement that play on licensed sites only occurs within the state of New Jersey. Federal law enforcement entities have also not provided evidence of challenges related to regulated online gambling activities in those 3 states. This is contrasted with the significant challenges associated with unregulated offshore online gambling, such as limitations on monitoring transactions and activity on offshore servers and low levels of international cooperation. The unregulated offshore gambling sites are not required to verify a player's age, identity or location, and do not provide the significant evidence trail that regulated online gambling operations provide. The National Fraternal Order of Police wrote in opposition to a ban of online gambling, describing the threats that exist in the unregulated online gambling arena. Not only does the black market for Internet gaming include no consumer protections, it also operates entirely offshore with unlicensed operators, drastically increasing the threat of identity theft, fraud, or other criminal acts. There is also evidence that these gaming sites launder money for organized crime and help to finance terrorist networks, and I agree. Any legislative attempts to ban online gambling will drive U.S. patrons to access the unregulated offshore gambling sites that pose greater risk to consumers. A federal ban also interferes with the state's right to decide what gambling is permissible in its borders and the right to create a regulatory framework that protects its citizens. The best way to protect our citizens and support law enforcement is to allow states to establish a regulated system of oversight and enforcement for online gambling that will help drive illegal operators out of the marketplace. And if they are looking to do so, if the states are looking to do so, New Jersey has set a model for regulation that protects its citizens. Other states that choose to allow online gambling can learn from that approach. Thank you, Mr. Chairman.
Thank you. I'll hold the record open for 5 legislative days for any members who'd like to submit a written statement. We'll now recognize our witnesses. We're pleased to welcome Joseph S. Campbell, Assistant Director, Criminal Investigative Division at the Federal Bureau of Investigation. Mr. Campbell began his career as an FBI Special Agent in August of 1990 and reported to the Chicago Field Office, where he investigated white-collar crime, public corruption, organized crime, and various drug matters. He also had a distinguished career since then, having served in numerous important positions, including as Supervisory Special Agent in the Counterterrorism Division, Weapons of Mass Destruction Operations Unit at the FBI headquarters, and head of the Joint Terrorism Task Force for the Denver Field Office. We appreciate you being here because in September of 2012, Mr. Campbell was promoted to Deputy Assistant Director of the Criminal Investigative Division, and I think you provided valuable insight. We welcome the Honorable Alan Wilson, the Attorney General of the State of South Carolina. Mr. Wilson was elected South Carolina's 51st Attorney General on November 2nd, 2010, and reelected again in 2014. As South Carolina's Attorney General, Mr. Wilson is the State's Chief Prosecutor, Chief Securities Officer, and the State's Chief Legal Counsel. Mr. Wilson joined the National Guard immediately after joining college. He was called to serve in Iraq, where he led the troops through Army fire and earned a Combat Action Badge. We thank you, sir, for your service to our country. Today, he continues his military service by providing legal support for soldiers and assisting in the prosecution of military crimes as Lieutenant Colonel in the Judge Advocate General Corps. We thank you again for your service. We're also pleased to have the Honorable Donald Klein, Douglas County Attorney in Douglas County, Nebraska. Mr. Klein was elected Douglas County Attorney in November of 2006. He was reelected again in 2010 and again in 2014. In his years as a prosecutor, Mr. Klein has tried numerous high-profile criminal cases. He is on the faculty at Creighton University School of Law, teaching the trial practice in criminal prosecution. He is a past president of the Nebraska County Attorneys Association and a member of the Board of Directors of the National District Attorneys Association. We also are pleased to have the Honorable Mark Lipparelli, member of the Nevada State Senate. He has an extensive private sector background, having worked for some organizations including Bally Technologies, Shufflemaster, Casino Data Systems, and in 2013, Mr. Lipparelli became a completed a 4-year term on the Nevada State Gaming Control Board, including his final 2 years as the chairman of that board. We have a good panel. We look forward to a robust discussion. We thank you all for being here, but pursuant to committee rules, all witnesses are to be sworn before they testify. So if you will please rise and raise your right hands. Thank you. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. If you please be seated and let the record reflect that the witnesses all answered in the affirmative. In order to allow time for members to ask questions, we would appreciate it if you would limit your oral presentation to no more than 5 minutes, despite the example, well, I set. But I'd be assured that your entire written record will be made part of the record. Mr. Campbell, we'll start with you. You're now recognized for 5 minutes.
Good afternoon, Chairman Chaffetz, Ranking Member Cummings, and members of the committee. Thank you for the invitation to appear before you today to discuss online gambling and the potential criminal activity that could arise within it. As Assistant Director of the FBI's Criminal Investigative Division, the responsibility to manage, coordinate, and direct investigative programs focused on financial crime, transnational organized crime, civil rights violations, public corruption, crimes against children, and drug-related and violent crime fall to the hard-working special agents and professional staff working with me. Together, we remain committed to the goals and visions set forth by FBI Director James Comey to uphold the Constitution and protect the American public from criminal wrongdoing. We appreciate the committee's interest in the threat posed by online gambling, which can have connections to many other forms of criminal activity. Illegal gambling businesses, specifically Internet sportsbooks, have become increasingly popular in the United States as well as abroad. The existence of these websites has grown exponentially over the past few years. The National Gambling Impact Study Commission reported illegal betting on sporting events in the United States is estimated to range between $80 to $380 billion annually. The Federal Bureau of Investigation works hard to establish and maintain strong partnerships with both public and private entities in order to combat illegal gambling. One of our priorities has been to work with private sector partners like the American Gaming Association to publicize our Internet Crime Complaints Center, IC3. The IC3 is an online tool which allows the public to report tips about suspected online criminal activity, including illegal gambling. Any discussion of issues concerning online gambling should include the potential for money laundering. Money laundering is broadly defined as any transaction that seeks to conceal or disguise proceeds from illegal activities. Thus, it is any act that converts proceeds gained from illegal activity into assets that appear legitimate. Money laundering can undermine the integrity and stability of financial institutions and systems, discourage foreign investment, and distort international capital flows. We suspect online casinos are potentially susceptible to criminal and money laundering schemes. Online gambling could provide criminal actors with the potential to be anonymous. The use of the Tor network, proxy servers, and encryption through virtual private networks could potentially conceal a player's identity, location, and true gambling activity. Criminal actors could fraudulently manipulate games and conspire with others to use their online gambling accounts to transfer criminally derived funds to each other. A private tournament or game could create a platform allowing one person to transfer funds to another person. Once the private tournament is created, the criminal actor could raise their bet to the maximum permitted bet and then fold or intentionally lose. The movement of funds, which appears as gambling winnings to one and gambling losses to the other, is simply a transfer of criminally derived funds. One of the goals of criminals who generate revenue from criminal activity is to launder their proceeds through our financial systems to make the funds appear legitimate. Criminal actors use numerous methods to launder their proceeds. One of those methods is through the use of casinos. Internet-based casinos, like physical casinos, can be used to launder criminal proceeds. A person's online gambling account can be funded through various methods. Some of these methods include prepaid cards, debit cards, credit cards, previous gambling winnings, or in-person presence at a physical casino. An individual wishing to launder criminal proceeds by funding their online gambling account at the casino could structure their transactions in efforts to evade regulatory reporting. Bank Secrecy Act regulations applicable to physical casinos also apply to legal online casinos. These Bank Secrecy Act regulations are designed to detect money laundering activity. Bank Secrecy Act regulations also require casinos to file BSA reports when the casino detects suspicious funding or gaming activity. The FBI reviews these reports regularly. I thank you all again for inviting me to participate in this hearing today, and I look forward to taking your questions. Thank you.
Thank you. Attorney General Wilson, you're now recognized for 5 minutes.
Thank you. Good afternoon, Chairman Chaffetz, Ranking Member Cummings, members of the committee. I appreciate the opportunity to be heard here today. I'd like to preface my testimony with the reality that the 2011 Wire Act revision is one that should have been debated legislatively, not decided administratively by a DOJ opinion. The members of this committee already recognize that under our Constitution, particularly the 10th Amendment, the states have virtually exclusive authority over gambling. As the Fourth Circuit has held, gambling regulation is an area where states have much expertise and competence, and it lies at the core of a state's police power, end quote. Each state is entitled to decide for itself how or whether to regulate gambling or to ban it altogether. This is the way our Founding Fathers intended the Constitution to work. The federal government should respect the rights of states, not destroy those rights. It should not legalize gambling activities the states make illegal. But the DOJ opinion strikes at the voters and congressmen have enacted. The executive branch cannot supersede the legislative. The original Wire Act, with its respect for state sovereignty and prerogatives, should thus be restored so that casino gambling does not operate over the Internet in the states which have outlawed it in their communities. In South Carolina, gambling is largely prohibited and has been throughout the history of our state. Our courts recognize that the public policy of the state is to prohibit gambling. In recent years, my office, our State Law Enforcement Division, or SLED, and various local law enforcement agencies have had to combat short-term proliferation of Internet sweepstakes cafes, which displayed Internet-based casino-like games on computer terminals and strip mall outlets, some of which even lured patrons with promises of free cell phones provided by the federal government. Furthermore, South Carolina's experience with video poker was traumatic. Video poker became a $2 billion industry in the state and carried with it such an addiction problem that there are stories where mothers have left children to die in cars while they played video poker. As a result of video poker, families were destroyed and gambling addictions proliferated exponentially. Robert Stewart, our then chief of SLED, even warned that video poker was bringing organized crime to South Carolina. Continued best efforts over the decades to protect our citizens from the threats posed by gambling, DOJ's revised interpretation of the Wire Act has opened the door to Internet gambling, turning on any mobile device in our state into a virtual casino. What South Carolina's legislature has specifically shut down, DOJ has reopened in another form with a single stroke of a pen. As demonstrated in letters from governors and attorneys general to Congress on this matter, states are befuddled that a 180-degree turn in federal policy on such an important issue was able to occur without public comment or input. Decisions with such broad national policy implications as the 2011 DOJ opinion, which abandoned 50 years of DOJ policy, should be debated by Congress, not left to a lawyer at the Justice Department operating within a vacuum. This unilateral opinion has opened a Pandora's box of enforcement issues for states like South Carolina. Overnight, a DOJ attorney transformed casino gambling from a tightly controlled activity requiring interstate or international travel for South Carolinians to an app on a smartphone available 24/7 with the tap of a finger. While it is reasonable to assume that one day in the future technology will be in place in virtual casinos to prevent these sites from being accessed in another geographic area, the reality is offices like mine charged with the responsibilities of enforcing our own gambling laws and protecting the public cannot be expected to rely on the good faith of massive foreign-owned gambling companies licensed by other states. Our system of government reserves intra-state matters, including the regulation of gambling at brick-and-mortar facilities and intrastate lotteries, to the states. But the Internet, as the Justice Department has successfully argued in the courts, is inherently interstate, and so are any gambling casinos offered online. States are ill-equipped to enforce gambling laws against interstate and international companies, particularly given the technological vulnerabilities of the Internet and age and location verification mechanisms that are subject to compromise. The 2011 DOJ opinion endangers citizens of states like South Carolina, especially our children. As a result of this opinion, states with strict laws prohibiting online gambling are forced to rely on the promises of foreign gaming corporations and the regulatory agencies of other states which have legalized online gambling, despite their best intentions. If we have trouble protecting our children from cyberbullying and other Internet crimes against children cases, then how can we expect a state to protect our youth from the potential harm of putting an online casino in their pocket? This is why I appreciate this committee's thoughtful efforts to address this serious threat to the citizens of my state and of our country and support legislation to restore the traditional interpretation of the Wire Act. Thank you.
Thank you. Mr. Klein, you're now recognized for 5 minutes.
Thank you, Chairman. Chairman Chaffetz, Ranking Member Cummings, and distinguished members of the committee, thank you for giving me the opportunity to speak today about the challenges of local law enforcement in protecting our most vulnerable citizens from the dangers that lurk in the realm of online gambling. I am the County Attorney for Douglas County, Nebraska. Myself and other colleagues around the country, the local DAs, prosecute over 95% of the crime that occurs in America. Douglas County encompasses Omaha and much of its metro area and is home to over 1/4 of Nebraska's residents. As this committee is well aware, prior to 2011, the Department of Justice interpreted the Wire Act to prohibit wagering of any kind over interstate telecommunications, including the Internet. The Wire Act essentially served as a federal prohibition to online gambling. In 2011, DOJ revised its longstanding interpretation of the Wire Act to only apply to wagers placed on sporting events, opening the door to online gambling in states without any input at all from law enforcement. The FBI has warned Congress that online gambling is uniquely vulnerable to criminal activity, but DOJ's dismantling of the Wire Act eliminated the risk of federal prosecution for online gambling. This left policing of online gambling to state and local officials with limited resources. For example, the Douglas County Attorney's Office, my office, has an annual budget of approximately $8 million. We have 56 attorneys dedicated to prosecuting approximately 3,500 felonies that occur within Douglas County. Our office is largely focused on violent crimes rather than online gambling. Moreover, while some violations of Nebraska's anti-gambling laws are felonies, many are misdemeanors, making it even more difficult to devote precious resources to enforcement. In addition to the limited resources available for enforcing the law, prosecution of gambling laws is especially difficult given that online gambling is inherently interstate and often has international implications. It has been my experience that law enforcement issues concerning in-person casino gambling are, for the most part, contained within the general vicinity of the gaming establishment itself. But online gambling easily crosses domestic and international borders and can often be accessed by anyone with Internet access. Several countries have legalized online gambling, and companies house servers that are accessible to people outside the host country. The primary companies operating these online gaming sites are massive foreign companies against whom it would be nearly impossible for my office, local law enforcement DA, to bring charges. These companies recognize that criminal prosecution by local officials would be very difficult, which creates even more opportunities for these companies to defraud players, launder money for much more dangerous operations. Even more troubling are the risks beyond illegal gambling associated with many online gambling sites. Credit card fraud, identity theft, and other financial crimes can occur when players disclose information that should be kept secure. Unlike other licensed and regulated activities, Internet gamblers often do not know who is operating the gambling site, if the games are honest, if the winnings will be paid, or if the money wagered will be used for criminal purposes. Once an individual chooses to engage in online gambling activities, there are few remedies that should they fall victim to a dishonest site. The anonymous, virtual nature of online gambling also increases opportunity to gamble more frequently. As I left my office yesterday, we had 2 new felony cases come in just from people who had gambling issues, and they obviously committed other crimes because of their gambling problems. As a county attorney, I prosecuted numerous crimes stemming from gambling issues, including white-collar crimes involving significant sums of money to neglect cases from parents not caring for their children due to gambling issues. Easy access to gambling is particularly dangerous to young people, who are 2 to 3 times more likely to develop a gambling problem. The Mayo Clinic compares the physiological impact of gambling to the impact drugs have on our brain's reward system. From a mental and emotional perspective, pathological gamblers are at an increased risk to develop stress-related conditions, major depressive episodes, anxiety disorders, or substance abuse issues. Compulsive gambling can also lead to financial loss, increased crime, lost time at work, bankruptcies, strained relationships with family members, and even homelessness. Finally, online gambling activities are extremely difficult to monitor because users can remain largely anonymous. Law enforcement often has limited tools to identify who is gambling illegal and from where they are engaging in the unlawful activity. Any smartphone, tablet, or laptop can be a vehicle for online gambling, and it is virtually impossible to pinpoint players who sign on from isolated networks. Members of the committee, thank you for the opportunity to share my concerns with you today regarding the dangerous consequences of online gambling and the resources required to support a state-by-state regulating scheme. Law enforcement is charged with protection of our most vulnerable citizens, but we cannot be expected to accomplish this monumental task alone. We need the important resources and expertise of the FBI and Federal law enforcement to ensure those online gambling companies preying on our citizens are brought to justice. Thank you.
Mr. Klein, thank you. Mr. Liparelli, you are now recognized for 5 minutes.
Thank you, Mr. Chairman, and members of the committee for the invitation to speak today. I am Mark Liparelli, and I was asked to present a result of the emphasis of my work for the past 7 years and my over 22 years of experience in the gaming technology field. In January of 2009, I was appointed by the governor of my state to the Nevada Gaming Control Board, and in January of 2011, I was elevated to the position of chairman. I also served on our state's gaming policy committee that adopted support of regulated interactive gaming in our state. This is relevant because during my tenure on the board, our state embarked on creating the first set of gaming regulations governing legal interactive gaming in the United States. I concluded my tenure on the Gaming Control Board in October of 2012, and since that time have provided advisory work to a number of entities engaged in the gaming, technology, sports, and investment sectors. I'm also the co-founder of the International Center for Gaming Regulation at the University of Nevada, Las Vegas, and currently serve as a Nevada State Senator. I would add that prior to serving on the board, I spent 15 years in senior management positions with some of the industry's leading gaming technology providers. The comments I make today are my own. As you continue to review iGaming and the related role of law enforcement, I can tell you confidently your committee is now in a position to benefit from a significant amount of deliberation and contribution from many well-informed and experienced operators, regulators, technologists, and industry experts. Unlike 2009, we are no longer in greenfield. We have learned a great deal in the past 6 years. The creation of enabling law and regulation in 3 states and a large number of informed studies and debates, as well as, perhaps most importantly, the creation, testing, and deployment of many iGaming systems throughout the world has created concrete knowledge that does now and should replace speculation. A healthy portion of the knowledge gained also comes from international markets that by our U.S. standards are not highly regulated. From a regulatory and law enforcement perspective, Nevada, New Jersey, and Delaware have been successful. Where there were concerns over licensing, protecting children and the vulnerable, player protection, tax collection, money laundering, and geolocation, these states have had good success. I have provided further discussion of these items in my full remarks. We know there have been many attempts to compromise these systems, but those issues are being revealed, thwarted, evaluated, and where warranted, new standards are implemented. This is a hallmark of gaming regulation of the traditional casino business. I would provide praise to my former colleagues in Nevada for beginning this effort, and particular praise of the efforts of Dave Rebuck in the New Jersey Division of Gaming Enforcement. Unlike Nevada, where regulations currently authorize only online poker, New Jersey chose to implement all forms of gaming. This no doubt expanded the scope of the effort and the energy to get it right. Like any innovation, ongoing diligence and continued product improvements will be necessary to meet the constant work of those who seek to compromise laws and regulations. The 3 existing U.S. markets and several regulated markets in Canada have now applied their knowledge to actual operations, and historical speculation has given way to their success and foundation knowledge. Future regulatory agencies that consider iGaming legislation will be subject to inquiry from those seeking clarity on the subject of licensing, product submissions, site approvals, employee registrations. These questions have been widely debated, tested, and largely addressed. To the degree possible, I have advised governments, law enforcement, and regulatory policy advisors to provide for broad statutory framework, but leave the specific requirements to the regulations. This approach gives regulators, the experts in the field, more opportunity to adjust to changing technology and provide flexibility where appropriate. Depending on the underlying products that may be introduced in the future, it is important that law enforcement and regulators strike an appropriate balance of clarity and regulatory policy. Where the intent is to allow full commercial-styled casino games, a more robust form of oversight is likely warranted. Where there are other forms of online gaming entertainment that fall short of these definitions, lighter forms of regulation may suffice. I have a couple concluding remarks. One, I would not leave this subject without specific reference to what I consider to be the much bigger policy challenge. In my opinion, illegal gaming operators need to be put in the spotlight. These operators continue to exist in the shadows and enjoy untaxed and unregulated operations. This is an area where states that have authorized gaming and those that have not need to work together with Federal law enforcement to continue to reveal these rogue operators. It is a continual effort, but cooperation between all levels of government, financial institutions, and licensed operators is critical. If illegal, non-taxing operators are allowed to freely compete untested and with unregulated products, the playing field will remain unlevel and consumers will be unprotected. Nevada, New Jersey, and Delaware, as well as many test labs, have begun to reverse this trend. In the short and long term, the lasting impacts on licensed operators will be significant. This knowledge must be shared with other states and the Federal Government as policies are shaped. Number two, the pace of U.S. legalization has to date been modest. This has largely abated concerns 5 years ago that iGaming would spread too quickly without proper oversight and without actual knowledge that it could be effectively regulated. Even with our law in Nevada in place for over 15 years, we remain only a poker jurisdiction, and several states, after study, elected not to proceed with iGaming legislation. Three, there's a host of attendant businesses that desire further clarity around iGaming policy. These include financial institutions, handset providers, network providers, credit card issuers, and many others. In nearly every case, they too seek the advantage of legal markets and seek to avoid those who are not providing such clarity. Four, technology's innovation is taking place at a higher and higher speed, and consumers are adopting mobile preferences. Newer technology to protect state choices on allowing or prohibiting iGaming is getting stronger and more diverse. For example, the proximity of New Jersey to New York and Pennsylvania highlights these protections in operation. Five, consistency in iGaming regulation is very important. The security of any system is made more difficult if we end up with an application code that varies widely from market to market. If policy changes are considered, this should be kept firmly in mind. And lastly, you have no doubt heard and will continue to hear from those who suggest that the risks are simply too great or that you cannot be given complete assurance that legal iGaming can be properly governed. As Chairman, these concerns were very real for me. No other state had taken up the regulation of iGaming, and we had a 75-year history to protect. My governor, himself a former Gaming Commission chair, Attorney General, and Federal judge, made it clear to me that outside risk was not in his or our state's interest. However, after spending 6 years with experts in the field, developers of products, independent test labs, and regulators from Alderney, the United Kingdom, Gibraltar, France, Italy, Malta, and the Isle of Man, Singapore, and many others, I can give you confidence that the regulated market model does work. That said, you must be willing to accept that this market, like any market, is not entirely bulletproof. As markets grow, there will no doubt be challenges. I expect we will uncover new risks that we did not anticipate despite our exhaustive efforts. State regulators and independent test labs have and will continue to act to address those challenges. Thank you very much for your attention. I am happy to answer any questions you may have.
Thank you. Before we get to our questioning, I have two UC requests. The first, the Chair notes the presence of our colleague, Congresswoman Dina Titus from Nevada. While she's not a member of the Oversight Committee, we thank her for the interest in the hearing topic, and I'd ask unanimous consent that Ms. Titus be allowed to fully participate in today's hearing. Without objection, so ordered. I also have a series of letters that I would ask unanimous consent to enter into the record. A letter from 8 State Attorneys General urging Congress to restore the longstanding interpretation of the Wire Act. A letter from the Nevada Attorney General, Adam Laxalt, expressing the need for congressional review of the Wire Act and the 2011 OLC memo. A letter from 16 State Attorneys General urging Congress to restore the longstanding interpretation of the Wire Act. A letter from Congressman Bill Young that was dated September 20th, 2013, stating online casinos are vulnerable to a wide array of criminal schemes. A letter from the FBI to Congressman Spencer Baucus dated November 13th, 2009, expressing concerns with online gaming and including its potential to be used for money laundering. Individual letters from various governors across the country, all expressing concerns with online gaming and the need to address the Wire Act. Arkansas Governor Asa Hutchinson from Arkansas, Utah Governor Gary Herbert, Florida Governor Rick Scott. Again, these are all individual letters. Florida Governor Rick Scott, South Carolina Governor Nikki Haley, Texas Governor Rick Perry, Indiana Governor Mike Pence, a letter from Congressman George Holding expressing concerns with online gaming, and a letter from the Family Research Council expressing support to restoring the Wire Act, as well as a Newsweek cover story on the issue. Without objection, I would like to enter these into the record. Without objection, so ordered. Now we'll get to the question. We'd like to recognize the gentleman from Kentucky, Mr. Massey, for 5 minutes.
Thank you, Mr. Chairman, and thank you for holding this hearing. Mr. Campbell, my first question is for you. Approximately how much of the FBI's budget is dedicated to regulating and enforcing laws on Internet gambling? What percentage, if you would? Not asking for an exact number.
I don't have with me the exact percentage related to the budget that we dedicate to it. However, I can tell you that
If you can move, all of you, if you can move that microphone up close and snug and turn it right there, you go. Thank you.
Got it. Okay. However, in regard to our investigations regarding this violation, it could cross a number of areas that, of course, are funded, such as transnational organized crime, potential terrorism financing, other criminal enterprises involved in it.
Have you prosecuted anybody for terrorism financing using Internet gambling as a nexus?
We do have one investigation that we did conduct where the individual used, among other things, gambling for money laundering purposes and so forth.
Was it one of these Internet gambling sites in one of these 3 states that allow it?
I don't have that information. I can provide you with more particulars on that.
How big of a priority is this, and how prevalent of a problem is it compared to, say, terrorism for the FBI, compared to terrorism, insider trading, counterfeiting, political corruption? Is it more important than any of those?
Well, it fits into the priority in the sense that as we go after critical organizations that can hurt America, and again, whether those are transnational organized crime groups, other criminal enterprise groups, terrorism, et cetera, we look for any and all violations that those individuals are involved in. And certainly, if it involves online gaming, we're going to pursue that threat and fully investigate that aspect. In addition, as information comes to us whereby online gaming may be occurring in an illegal manner or promoting those types of threats, we're going to drive most definitely as a priority.
But your testimony is that today, so far, you are not aware of any terrorism that's been financed using Internet gambling in any of the 3 states.
As I said, I can take that back, and we can do some further analysis.
But right now, you're not aware.
But as I sit here, I do not have that answer.
Can't, Mr. Campbell, following up, can't states just pass laws to prevent their own citizens from gambling on the Internet?
Well, certainly it's up to the states to determine how they might want to police online gaming. From our perspective, we use a number of statutes, the Illegal Gambling Business Statute, Unlawful Internet Gaming Act as well, the Travel Act, the money laundering statutes, bank fraud, wire fraud, mail fraud, et cetera. And we partner with states in investigations and prosecutions.
Attorney General Wilson, same question for you. Can't your state just pass laws regulating this in your state?
It's my opinion that it would not be practical for states on a state-by-state in a quilt-like matter to pass laws on something that the federal law has passed unanimously across all 50 states.
Is that because of enforcement?
It was very difficult from an enforcement purpose. I mean, it's extremely difficult to enforce.
Well, here's my concern, and my next question is for Mr. Liparelli. And I want to know if you have the same concern that I do, that if we pass a national online gambling prohibition under the presumption that it's necessary for federal legislation to overturn essentially overturned state laws to deal with a state problem on it, because they don't want to do it on a state-by-state basis. Couldn't that logic be used in the same way with gun control, for instance? Because if a state's allowed to sell guns in one state, that makes enforcement of gun control laws in another state difficult. Isn't there sort of the same logic at play there, or do you share that concern?
I wasn't prepared to discuss gun control in today's hearing, but what I would say to that question is—
Well, let's just back it up to the 10th Amendment then.
Right. What I would say to that question are two things. State laws that exist today that either authorize or make illegal gaming operations apply every bit as much to something that is exposed on the Internet as it would be in a brick-and-mortar facility. For example, in the state of Nevada, you no more have a right to expose a gambling game on the Internet as you do going down the street and opening up a building without a gaming license. So those state laws apply regardless, so that would be my response. A state law already prevails regardless of whether it's Internet or not.
So just in closing, I would say that I do have that concern, that if we use this logic at the federal level, that it's hard to enforce, for instance, gun control laws in one state, so we have to have a universal ban. That seems like the same logic that we're using here by prohibiting Internet gaming. That's just my concern, Mr. Chairman, and thank you. I yield back.
No, listen, I appreciate your thought on this. I know you care about this issue. I would just add to my colleague that the Department of Justice, second only to the financial sector, more than $1 billion in fines, $1 billion. So they are pouring an awful lot of resources into this, and there have been quite a few incursions in this category. We'll now recognize Ms. Watson-Coleman for 5 minutes.
Thank you, Mr. Chairman. You know, the 3 states that have created a regulatory framework to allow license on have already greatly reduced the risk of collusion of money laundering through the regulated sites. And Mr. Campbell, I need to ask you, has the FBI had any successful convictions of a regulated gambling operator, or have you seen an increase in criminal activity through the regulated gambling sites?
So for those businesses that are operating illegally outright, however, we do look at information that we receive that could demonstrate that a regulated gambling business might be acting illegally. I think an important point to make is that individual subjects, criminals, could still be utilizing any legal gambling business for illegal activities such as money laundering and then to support other illicit criminal activity.
Possibly. However, has the FBI any record of these instances that I've asked about?
I don't have the specific details regarding that. I can take that back and see whether that does in fact exist.
And whether or not you've seen an increase in criminal activity on those sites. The other thing, Mr. Campbell, I wanted to ask you, what are some of the challenges that the FBI faces in going after illegal online gambling schemes that are unregulated and offshore, and are there measures to counteract those challenges on the regulated sites?
Well, certainly as with any investigation, whether it's nationally or globally based, we're going to utilize all investigative techniques in order to gather information about what criminal activity may be occurring, which includes working with our state, local, federal, and private sector partners, and even foreign government partners related to that particular threat. So regardless of the circumstance, we're going to apply the same techniques and utilize every capability to obtain evidence for a prosecution.
I can appreciate that. So I just kind of want to, for the record, in that might be the case, you have not come here today with any particular knowledge about problems of this nature in the 3 states that have the regulated online gambling. Is that, and you would have to find out if there's such a record and let us know. Is that right?
That's correct. I would have
Thank you,
to
Mr. Chairman.
provide you some other information on that. That's correct, yes.
With a little bit of time that I have left, I'd like to contrast the kind of challenges that have been discussed here by the panel with what happens when states do regulate online operations. And so, Mr. Liberelli, I'd like to know from you, from your experience, what controls are in place in regulated online gambling sites that make it easier to catch attempts at criminal activity like money laundering or collusion?
It's a very fair question. One thing that is probably misrepresented too many times in the public is the U.S. regulated industry of iGaming dramatically differs from our counterparts in most foreign jurisdictions. We set in place what many people in foreign jurisdictions criticize us as a very tight system. So everything from player registration all the way down to player transactions is completely transparent to the regulator. So there is a relational database that identifies issues associated with potential fraud, collusion, player manipulation, credit issuance, the laundering of money. It would be my considered opinion that if you were going to try to launder money, a legal regulated site would probably be the last place that you'd want to try to do that. From a law enforcement perspective, the tools we put in place are quite robust and would lead right to the doorstep of those that were using a legal site for those kinds of purposes.
I know that no system can be perfect, and no enforcement effort is actually perfect. But to your knowledge, are there sufficient layers of identification requirements that would ensure that an individual is playing from a legalized state in a state that has regulated gambling?
There are.
Geolocation issue.
There are, to answer your question directly, and separately beyond that, it's not just simply identifying the IP address. The standards that I think were referenced by one of the witnesses here relate to very specific knowledge of the location of the transaction. It also incorporates tools that require users to disable certain functions on their computer so as to prevent people from disguising their location. If those applications are actually operating while the site is accessed, the site will deny access. So there are a number of technical standards that have been put in place and tested to prevent that from happening.
Thank you, Mr. Liberelli. My time is up. Thank you, Mr. Chairman.
Thank you. Now I recognize the gentleman from South Carolina, Mr. Mulvaney.
I thank the Chairman. Thank you, gentlemen, for participating. Alan, thanks especially for coming up. It's always good to have folks from back home contribute to this process, and thank you for your service to our state. Help me, because when I heard you were coming up, I was excited, but I didn't expect you to be on this side of this issue. You've taken some positions that I support in other areas, from health care to gay marriage to EPA regulation. You've been taking the position against federal control, which and I read your testimony today, not the stuff that you were able to get to when you opened, but your testimony is got some really good lines in it. The members of this committee should recognize that under our Constitution, particularly the 10th Amendment, the states have virtually exclusive authority over gambling. Each state is entitled to decide for itself how or to whether together. Congress has always recognized the preeminent state interest in gambling regulation. I could go on. And then to have you come up and take a position here that sounds like you're for federal control, I can't square those two things. I've got this last quote, which says that the DOJ opinion strikes at the very heart of it should not legalize gambling activities that states make illegal. I get that, and I agree with that. The federal government should not legalize stuff that the states have made illegal. But I'm waiting for the other half of that statement, Mr. Chairman, which is, should the federal government also make illegal that which other states have made legal? And there's 3 states who have done that. So help me square these two things.
I'm going to ask, first off, let me say this. I'm not up here, I'm not going to speak for anyone else today, I'm not up here to say that gambling should be made illegal. I think if New Jersey, my wife's from New Jersey, love your state, if New Jersey or other states want to have a robust gambling industry, they should be free to pursue that. The members in this room who want that should be allowed to have it.
But if the bill passes, that's why she's here. She's afraid if the bill passes, she loses the right to do that.
What we're talking about is interstate commerce, which Congress has the authority to regulate under Article 1, Section 8. There is no dispute up here that Congress can write the Wire Act, that Congress can regulate online gambling because it's interstate in nature. That is not the dispute. If
Alan, let me stop you there, because I think that's right. I hope we're moving to an area we can agree on, because I'm wondering if there's not a better way to do what we want to do in South Carolina, where it's not legal, but still allow New Jersey and Nevada to do what they want to do, which is to use technology instead of regulation. If we could figure out a way to make sure that only New Jersey residents gambled online in licensed New Jersey enterprises using technology, isn't that another way to accomplish what you want to accomplish?
I believe that if, online gambling, if it's allowed by the federal government, you're basically putting every pocket of every teenager or young person who wants to be able to access it.
I get that, but in your testimony, what you say is that the reinterpretation essentially allows states to operate online casinos in states like Nevada, Delaware, New Jersey, without any assurance that these online casinos are not being accessed in states like South Carolina. You also say that the original Wire Act, with respect to states' rights and prerogatives, should thus be restored so that casino gambling does not operate over the Internet in the states which have outlawed it in their communities. And what I'm asking you is, isn't there perhaps another way to prevent kids in South Carolina from accessing gambling sites, legal gambling sites in New Jersey, Nevada, or Delaware, other than federal regulation?
And I don't know that that way exists. I heard Ms. Coleman eloquently say that she believes as a matter of policy that verification can be enforced. I saw the little points up there on the map. I don't know if those were 18-year-olds or if people crossed the river to gamble. But the point is that if you make online gambling legal at the federal level, then you've basically legalized it in states where they don't want gambling at all.
Your objection to this is not that the information might state lines in the process of going a person in South Carolina access something in Nevada. That's the interstate nexus for you here, correct?
Correct.
So if we could figure out a way to fix that, I would simply suggest if there's a way to fix it through technology that Mr. Lipparelli has mentioned, maybe that is an alternative and less intrusive way to deal with the issue, and here's why I care. And I have all the respect for my colleague from New Jersey, but unbeknownst to you and maybe the other folks on the committee, in fact, maybe folks on the committee here, she's introduced a bill that has a lot of similarities to what Mr. Massey mentioned earlier, which is to ban Internet ammunition and gun sales through a similar requirement to what you've just been talking about here, by making people actually show up in person to show their ID. I can't remember the name of the bill he's seen. And that's one of my fears here, is that they're asking you to, instead of being consistent in the state rights position, to come out and say, well, here's a place where we really do need federal intervention so that people in South Carolina can't access legal Internet gambling in Nevada, and then use it as to say, oh, by the way, it really is hard for New Jersey to enforce our state laws on gun control because you can just go online and buy one in South Carolina. And that's what I'm worried about, is that we're going to go through regulation and expand the role of the federal government as opposed to limit it. So anyway, with that, I yield back the balance of my time. Sorry.
Go ahead. May I respond real quick? And Representative Mulvaney, I agree with you on many of your points. I would just add that one of the points regarding what was the last comment you made? It was the gun control. I absolutely would be against that. I just believe at the end of the day that online gambling is a very unique industry, and that when you make online gambling proliferated across the country, it is very difficult for states like South Carolina to enforce its gambling laws. I believe under the 10th Amendment, states should be able to outlaw Internet gambling, but those states that want gambling in there can certainly pass those laws that allow it to occur.
Last question, Mr. Chairman, I promise. but
I need to go to, no, I need to go
come on,
to.
you took like 10 minutes.
I know, and I didn't ask any questions. So we're going to go to Mr. Cummings from Maryland.
Thank you very much, Mr. Chairman. You know, I'm listening to all this, and if I were a judge listening to this, the first question I would want to get to is the bottom line. And what I said in my opening statement is about money. Would you agree that if we were to outlaw online gambling, that the bricks and mortar people would make more money? Anybody disagree? I don't see any disagreement down there. And I guess the reason why I'm getting to that is because, I mean, you know, we in the Congress, but I don't have the kind of money that the big players are playing with. And we have to we're trying to figure out how to deal with this dispute. But there's some things that are coming through from what you're saying that I think we can kind of get down to the bottom line of this. It sounds like the issue of illegal gambling, which I think all of us want to get rid of illegal gambling. That's one thing, Mr. Campbell. And my question is so you don't feel that you have the tools to deal with the illegal gambling? Hold that for a second, hold that. And then I want to come to you, Mr. Leparelli. Let me ask you, with you, it sounds like what you're saying, if we can steer more gamblers, in other words, if the states can do the regulating, then a lot of the problems that Mr. Campbell talks about should be resolved, because you use the term relational database. What he's talking about is information. And you're saying we're getting the information that would actually allow him to do a more effective job. Am I missing something? Because this is what seems like everything that you all have said. To me, this whole thing boils down to what I just said. Help me.
Mr. Cummings, the requirements that we put in place were exactly that. If we're going to allow online gaming, there will be player registrations, there will be complete tracking of activity, so that to the extent these sites were ever to be used or attempted to be compromised, the audit trail or the transparency trail is there for the regulators. So the quick answer to your question is yes, we want players to move to and off of illegal gaming sites. That's often missed in this discussion, is these illegal sites are readily available to all the U.S. public. They were available prior to 2011 letter that was, or the opinion that was authored. They were available. And by the way, the reference of the chairman with respect to the substantial fines that were paid by people who broke the law, who were illegal. Those weren't legal regulated sites that paid those fines. Those were people that were trafficking in our country, in our states, who ran to the steps of the Justice Department and said, we want to get right, and we're willing to pay to do that.
So now, Mr. Campbell, can you answer my question? I gave you some time to think about it.
Certainly, sir. As I mentioned earlier, we use a variety of statutes to go after individuals and organizations that are involved in illegal online gambling. And then, of course, we use statutes such as those and others then to target those criminal organizations that are using online gaming to support other types of more serious and nefarious criminal activity, like human trafficking, like narcotics trafficking, corruption, that type of thing. So we use a variety of tools in order to target that particular threat.
Now, going back, in 2011, going back to a point you made, Mr. Leparelli, the Department of Justice Office of Legal Counsel interpreted the Wire Act to prohibit only sports betting based on the text of the statute and the relevant legislative history and other materials. After that opinion was issued, some states legalized Internet gambling within their borders and regulated it. Some have questioned that legal opinion. Now, Mr. Wilson, DOJ cited two conflicting court decisions. One was a Federal Circuit Court of Appeals case known as In Re MasterCard, I know you're familiar, which held that, and I quote, "A plain reading of the statutory language clearly requires that the object of the gambling be a sporting event or contest," end of quote. The contrary position was taken by a lower federal court in U.S. versus Lombardo, and is that right? Is that correct?
I haven't read that case.
Okay, no problem. DOJ took the position of the higher court, citing the legislative history and a natural reading of the statute. Mr. Campbell, some of today's testimony has criticized the DOJ opinion for opening the door for Internet gambling in the states. But illegal, unregulated Internet gambling existed in the states well before 2011, the opinion, and continues to pose a risk of harm to citizens. Is that correct? Is that correct, Mr. Campbell?
Well, as I can't speak to exactly the circumstances before 2011, But again, we use a variety of tools to target that threat as it exists and as we receive that information.
But Mr. Leporelli, can you answer that
Mr. Cummings,
about prior to 2011?
Yeah, Mr. Cummings, I would answer that by saying the opinions that people form about the 2011 letter, I think, get mischaracterized in such a way that before 2011, there was a criminal division letter in the form of a one-page letter sent to 2 different states that drew a different conclusion. The 2011 analysis by the OLC was a, I think, 16-page, fairly substantial opinion that interpreted the Wire Act. The decision of the Justice Department prior to that came in the form of criminal justice interpretations that came in the form of a one-page letter. In our state, even though we had that opinion as a criminal interpretation by Mr. Chertoff at the time, we no more had a sense of whether that was the only potential interpretation of the Wire Act and whether that would prevent us as a state from doing what we thought could be done legally. And you see the impact of that. In 2011, that opinion changed. So I would say that there was a one-page letter that interpreted the Wire Act one way, and now a 16-page opinion that interpreted a different way. Both of those were interpretations of an underlying law that a lot of people struggle with.
Thank you very much, Mr. Chairman. Thank you.
Thank you. Members are advised that we have a vote on the floor. There's 11 minutes left. It's the intention of the Chair to recognize Mr. Heiss of Georgia for 5 minutes and then go into recess. We'll resume with the Democrats going first after the 2-vote series. So, Mr. Heiss, you're now recognized for 5 minutes.
Thank you, Mr. Chairman, and I want to thank you for holding this hearing today and for each of those who are joining us on the panel. Before I begin my questions, I've got to make it perfectly clear that personally I am opposed to all gambling in every shape, form, or fashion, be it in person or online or whatever it may be. Having been a pastor for over 25 years, I've personally seen the destruction of various addictions and gambling being among them. So this type of hearing puts me somewhat in a quandary to begin with, because I am opposed to gambling altogether. And I fully agree with Georgia's Governor, Nathan Deal, who has publicly opposed the construction of a casino in Metro Atlanta, and who I also know for a fact opposes any lottery offerings that resemble casino games. So I'm opposed to gambling. But that being said, I'm also a supporter of the 10th Amendment and our Constitution and the right of states. And whether the fact is the people of Georgia voted to have a lottery. And there's no question that the Georgia lottery has contributed over $1 billion to the Hope Scholarship and pre-K education since its inception in 1994. No one can deny the contribution to those programs. And I also know that the Georgia Lottery has been in recent years exploring online sales, and in fact they've contributed and invested a considerable amount of money to ensure that those sales that customers make are in accordance with both state and federal law. So all that being said, my first question is really to each of you in a brief answer, but if the technology exists to ensure that online sales are kept away from minors and kept within the state of Georgia alone, why does the federal government have a role to play? Or does it? I'll just start, Mr. Campbell, with you.
Right. So I'm not here to take a particular position in regard to all the aspects of your question, but just again to reiterate that the FBI enforces the laws as they exist, and as we receive information about criminal activity, that's really our role.
Mr. Wilson.
The Wire Act was originally ushered in through the Kennedy administration, when then U.S. Attorney General Robert F. Kennedy was the Attorney General for the United States, in an effort to help states. There is no violation of state sovereignty or 10th Amendment, because Congress has the authority under Article I, Section 8 to regulate interstate commerce. A brick-and-mortar building is not—
Talking about in the state of Georgia, though, not interstate. If
If you go
If the
online.
technology is there to stay within the state, what role does the federal government have? That's my question. And please be quick. I've got just a couple of minutes left.
If it crosses state lines in an internet transaction, you have a role in that regard.
That is not my question, though. Mr. Klein?
Well, the very essence of what we're talking about here is the Internet has such interstate complications. As a local prosecutor, that's what we're looking for, is some help from the federal government to say, hey, we can't handle this, and I'm not aware of any way. If Nebraska said, we want to ban the Internet, there's no way that's going to happen. People are going to have access to the Internet. So
Mr.
we're looking for
Lipparelli,
help
what would you
here.
say?
The technology exists to keep it within the state border, so in your direct question shortly is that there wouldn't be a role in that sense.
Of the federal government.
There may be business ideas down the line that may incorporate multi-state activities, but the quick answer to your question is they wouldn't have a role.
Okay, Mr. Campbell, are you aware of any circumstances where the Georgia Lottery has failed to comply with state or federal law?
As I sit here, I really do not have any information about the Georgia Lottery in general, sir.
Okay. Well, my time is wrapping up, but it just seems to me that the federal government should not be dictating to the states how they operate their state lotteries or casinos, state-sanctioned casinos, if those states have chosen to go that route. And, I mean, we've got to protect the 10th Amendment, whether or not we like the gambling issue as a whole. And frankly, if there's any legislation that infringes upon states' rights in that regard, I believe it flies right in the face of our constitutions and the limited powers that the Constitution provides. So with that, Mr. Chairman, I thank you and I yield back.
Impressive timing. The committee is, with 5 minutes, 30 seconds left in the vote, the committee will stand in recess. We will return no sooner than 3:10, but be flexible as it regards to be a little flexible in terms of when the vote series is concluded. We'll stand in recess and we'll be back and continue from there.